Excellency, Monsignor Sanchez Sorrento, thank you for your invitation and an opportunity to be here. Why I emphasize this moment? Because if I am not enough lucky to be in opportunities like this, I always greet all by two words, dear all, and I really feel here among friends. And when I started with two words, I will add two more words, very simple words. One mentioned by Mr. Torres, who spoke recently, and this word is commitment. The second very simple word is passion. And I will take both of these words with me in my home and in my court and tell my judges about these two words, because it proves, these two words proves that we are fighting corruption and fighting organized crime, not only in professional way as our duties, but it became the way of our life. I thank you for this. I will start with my presentation, and it will take me only 45 minutes. Oh, you are, no, it will be enough 15 minutes because you are enough concentrate. Today's basic guiding principle of free movement of goods, services, money constitutes quite a challenge for modern society. Common market, community without borders, globalizations are factors which facilitate the fluctuation of people. Those factors provide opportunities for business to develop, the legal ones, but unfortunately the illegal and criminal ones as well. The crimes became more sophisticated, spreading their activities across the borders of one state, gripping to the governmental system. So it is sometimes difficult to separate legal from illegal segments. Unison answer of the judicial authorities of the modern society to the situation is an imperative. EU, United Nations and the European Union has already built the efficient and powerful legal framework to fight the crime. This activity is ongoing process, but a legal tradition, philosophy, and existing complementary laws define the integration of such provisions in the national legal system. It cannot be avoided easily. Putting on the hat of a spirited judge can be more difficult as it may seem. Passing the law, setting up the legal framework is only first step, since the provisions have to be applied to the particular case. Hence is the importance of the national courts, especially of the highest courts in the respective states. Give or take, the Supreme Courts show guidance to the lower courts by interpretation and or explanation, as well as by applying the provisions which origin in international legal instruments, for example, conventions, treaties, regulations, directives. This is of utmost importance when the human rights are at stake. The highest courts should be guardians of the legal system with the view of protection of human rights. Approximation of legal views and standards of the Supreme Courts of the respective states and harmonization of their case law concerning protection of society from the crime and also preserving the human rights of the perpetrators should be their common goal. The unanimous answer of the judiciary to the crime contributes to the safety, security, and finally to the peace in global community. Judicial cooperation at that level is essential. The rulings of courts, including the highest court, implicating the cross-border elements, have effects not only within the concerned member state, but also outside of its border. The courts in one state must be able to recognize and understand the decision of their colleagues from some other state and consequently to enforce such decision. The national courts judges must be aware of the fact that their rulings have effect in wider community and induce the responsibility for those rulings. The highest courts of the states are carrying the great responsibility. In that view, their cooperation and collaboration are essential and important. Establishing the firm bonds between supreme courts of respective states, linking them in vertical cooperation, is a path to mutual understanding and effective network. Consequently, this will contribute in setting up the efficient and strong tools to fight the national as well as international crimes, safeguarding in the same time the fundamental human rights. This is also a way for establishing the solid and firm ground for appliance of the principle of mutual recognition between judicial authorities of different countries in everyday practice. Namely, in the European Union, the mutual recognition was promoted as the cornerstone of judicial cooperation, already at the Tampere European Council in 1999 and introduced by the Maastricht Treaty under Title V, Provisions on Common Foreign and Security Policy. As it has been said, open borders can easily be misused by the organized crime to fight an organized crime spread across several countries, or to bring to justice an offender who tries to hide in some country, or to hear the testimony of a witness who is in other country. Judicial cooperation in this direction is really necessary. A traditional cooperation through mutual legal assistance may be slow and complex at times. It no longer corresponds to the today's reality where people circulate easily. A more advanced form of judicial cooperation is needed, and this is a mutual recognition of judgments and judicial decisions, a process by which a decision taken by judicial authority is recognized and enforced by other countries as if it was a decision taken by the judicial authorities of that later country. This is a key concept in the field of judicial cooperation, as it helps to overcome the difficulties stemming from the diversity of judicial systems. Enhancing the mutual recognition aims to uplift the efficiency of cooperation between authorities. It is based on mutual confidence and common respect of human rights and fundamental freedoms as they are set in the treaties. Seen from the judge's perspective, embracement of this transnational dimension arouses not only technical questions derived from comparative differences, but also legal and political ones. Legal problems relate to the incompatibility of particular legal systems, as well as their interaction capacity. In other hand, political dilemma relates to the role of judges in the jurisdiction of respective state. The developing and strengthening of freedom, security, justice, and consequently peace is one of the main aims of modern society. These endeavors are necessary in building mutual trust and the role of law. In the same time, this is the way to give judiciary solid and efficient framework so it can fulfill its duty. But this framework should be put in the hands of competent, independent, and impartial judge. Trafficking on human beings, breaching the human rights, and corruption present the cancer of the modern society. For the organized crime, there are no restricted zones. They have no scruples, and they does not refrain from corrupting anybody and everybody in gaining their goals. But in today's world, there are few things worse than corrupted judge and there is a little, if anything, one can do to fix him or her up. The judge and the judiciary are the ultimate legal sanctuaries for the victimized, wounded, and disempowered persons. If that sanctuary were compromised, there is no chance for peace. And if I may quote one report, even from 2007, from Transparency International, it clearly said, it is difficult to overstate the negative impact of corrupt judiciary. It erodes the ability of the international community to tackle transnational crime and terrorism. It diminishes trade, economic growth, and what is more important, human development. The legislation lives only through practice, through rulings of the judiciary in particular case. The judiciary, judges in the first place, are creators of justice, which is determined not only by their understanding of some provisions and their appliance in particular case, but also with their integrity and commitment to bring the justice. Adding to what has been emphasized earlier, strengthening of the legal standards and approximation of the case law will increase the mutual trust into each other's legal system and will result in enhancing the principle of mutual recognition. There is a common consensus that it should be supported and broadened beyond the borders of the European Union to all countries. Especially the effort should be concentrated in searching, seizing, and confiscating the assets of the organized crime. The organized crime understands only a talk of money, since gaining the money is their ultimate goal, no matter what. Dispossessing of the money is what hurts them most, since their only purpose and their essence reflect on the fact how much they, I will not say earn, but collect money. On the other hand, seized means should be used to ease the pain and suffering of the victims of the organized crime. In order to achieve more effective judicial cooperation in criminal matters, in fighting the organized crime, the assessment of current legal instruments can open new frontiers and direct new legislative proposals toward effective development of common judicial area. Only networking and linking of the judiciary, especially judges, in vertical and horizontal cooperation, can give an answer to those challenges ahead of us. And finally, it should be strongly emphasized that the responsibility of judges, practitioners who apply the law surmounts the national legal system and borders of the concerned state. And that's why we are here today and yesterday. The community gives the security and confidence to its members, but it should be protected from criminals, whoever they are, so it could be the safe place to live in. I thank you.
Thank you.